Are we ready? Good morning. Good morning again. Good afternoon if you are in Africa. Good afternoon if you are in the East Coast. Uh, good afternoon. Good morning if you are in the West Coast. This is Dr. Olu Asekun here again. Can you please let me connect it so I could see the questions? This is Dr. Olu Asekun here again. Welcome to our live podcast. We do this every Wednesday, 12 p.m. Central Standard Time. That is 1 p.m. Eastern Time. That is 10 a.m. Pacific. And that is currently 6 p.m. Nigerian time. So if you are joining us for the first time, thank you. If you have been a regular on the program, thank you also. Remember to subscribe to our channel so that whenever we go live, you can be notified. So today, we are discussing misinformation. There's a lot of misinformation. There's a lot of misinformation relating to immigration. So we are discussing misinformation today. Are these the ones you? All 3 pages? Okay, we are discussing misinformation today. There's a lot of misinformation going around regarding immigration. So if there are things that you have heard concerning immigration and you wanted to confirm it, whether it is true or not, this is the time to do so. Apology about that. Yes, we are discussing misinformation. So if there are questions, if there are information that you have received concerning immigration and you are not sure whether it is true or not, here is an opportunity to verify. Here is an opportunity for you to ask the questions. There's a lot of misinformation out there. There are lots and lots of information online that are not true. There are some information that are half truth, and there's some information that they are outright fabrication. They are myth. So a lot of things are going on there. So what we have done is to compile some of the misinformation that verify whether it is true. Here is an opportunity to do so. So the first one here on our list of immigration misinformation: immigrants will take American jobs, lower wages, and especially hurt the poor. It is easy to immigrate here legally. Why don't illegal immigrants just get in line? Immigrants abuse the welfare state. Immigrants increase the budget deficit and government debt. Immigrants increase economic inequality. These are more like political statements. Yeah, I'm actually expecting to discuss questions relating because these ones are more like political statements. I mean, what some politicians use to campaign or to win election. They know that these things are not true, but they just say all these things in order to win election, especially in red states. Okay, immigrants are a major source of crime and are more likely to commit crimes. Immigrants pose a unique risk today because of terrorism. The U.S. has the most open immigration policy in the world. All these things are not true. Is it true that you become a U.S. citizen upon marrying a citizen? No. Okay, this is a question. The answer to that is no. You don't become a U.S. citizen upon marrying a citizen. When you marry a citizen, there are process and procedures. So while your marriage was less than 2 years, you get a conditional green card. But if it was approved when your marriage has already been 2 years or more, then you get a 10-year green card. So you still have to wait and meet the requirement of citizenship before you can even apply for citizenship or become a U.S. citizen. Marriage to a U.S. citizen does not make anyone a citizen. You have to follow the procedure. I heard that they are ending DACA and that it is a violation of law. Is that true? Well, that no court has said that DACA is a violation of law. In actual fact, that DACA is still current and there are people still on DACA. What the court ruled on was that the there was an extension, there was an attempt to extend DACA to cover some other people that were not previously covered by initial DACA, to cover parents, to cover some other people. So the Republicans challenged it in court, and the court said that it is only the Congress that can do that. But the court did not tamper with the existing DACA. The existing DACA is still current, and those who are previously on DACA, they still continue to get extension of their DACA status. DACA is what's the full meaning again? Deferred adjudication for childhood arrivals. Yes, deferred adjudication for childhood arrivals. So, because if we just keep saying DACA, people may not understand what we are talking about. Is it true that for asylum, you just have to show up at the border, claim asylum, and then you are approved? No. This is half truth because you can actually show up at the border and request asylum, but that does not mean that your asylum will be granted right away. You still have to go through the process. You have to follow procedure. You declare your intent to apply for asylum. They will conduct what is called credible fair interview for you. So if you pass that, then they will go ahead and give you application for asylum and ask you to apply for asylum. And you have to apply within 1 year of your entry into the United States. And if you come in through the border and request asylum, you will be placed in removal proceedings. So you have to file your application for asylum at the immigration court. So you'll be placed in removal proceedings and you need to file your asylum application at the immigration court. Next question. Is it easy to get your immigration case expedited? All you have to do is submit a service request. Well, some applications are eligible for expedited processing, whilst some other applications are not. Uh, Majority of non-immigrant change of status are eligible for expedited processing. But even for those applications that are eligible, there is an additional payment. There's an additional filing fee payment. So you, depending on the type of application, for expedited processing, which is called premium processing, for some application you pay 1,500 extra in addition to normal filing fee. For some other application, you pay $2,500 for expedited processing in addition to the regular filing fees. So some applications are eligible, some applications are not. But I can tell you, application for green card, I-485 is not one of them. I-485 is not eligible for expedited processing. I-130 application is not eligible for expedited processing. So that I can tell you. I-360 application is not eligible for expedited processing. There are a lot of applications that are not eligible for expedited processing. Expedited processing is only available in very, very limited situations, especially change of status for non-immigrant status. The only immigrant application that you can expedite is the I-140 immigrant petition for alien relative. All the other applications, you have to follow the normal process. So I'm reading the question again. Is it easy to get your immigration case expedited? All you have to do is submit a service request. Actually, service request does not expedite cases. Service request is more like an inquiry. Service request is more like asking question. What is the status? What is the update on my case? So that is what service request is all about. It is not a means of expediting. In some cases, service request may trigger action on your case. So So if a service request is submitted and then immigration acted on it, it is not the service request that made it expedited. It just triggered the processing. So sometimes when a service request is submitted, it can trigger action on a case, especially where the case has exceeded processing time. So a service request may trigger action on such a case. The next question: only women qualify for VAWA? No, both men and women can be abused. In this modern day and age, we have seen women abuse men and we have seen men abuse women. So even though VAWA was originally meant for women, but it has been shown that both sexes can be abused. So both men and women can apply for VAWA. The next question: to qualify for VAWA, the abuse suffered must be physical. No. The abuse suffered may be physical, it could be emotional, it could be psychological, it could even be verbal. So abuse have different form. It could be mental abuse, it could be emotional abuse, it could be verbal abuse, and it may also be physical abuse. So all forms of abuse will be eligible for VAWA. It is not limited to physical. The only advantage with the physical abuse is that it's so obvious. So it may be easier to prove, it may be easier to establish, but it does not necessarily have to be physical alone. The next question: USCIS will contact your abuser to tell them you are filing VAWA. No, that is not the case. The VAWA application is treated in a confidential form. However, if USCIS have reasons to doubt any of the documents submitted in support of your application, they can use public record to verify. For example, if you submit a list that immigration believe that is fraudulent, they can contact the landlord of the property in question. They can use public record to verify. They will not contact the abuser because they don't want to put your life at risk, but they can do other means of verifying the document you submitted in addition to your VAWA, in support of your VAWA application. Yes, USCIS can verify all that, but they do not ask the abuser questions. They do not go to the abuser to let him or her know that you apply for VAWA. That is not the way it works. The next question: is it true that immigration can arrest you and then immediately deport you for overstaying a visa? Well, that is yes and no, because that depends on the policy of the government in power. That depends on the policy of the government in power. The immediate past administration, the administration of President Donald Trump, yes, they were doing that. You don't have to commit any offense. You don't. In fact, they can come to your apartment and get you arrested and put you in removal proceedings. Yes, it can happen, but it depends on the policy of the administration in power. So the good news is that the current Biden administration have decided not to do that. In fact, the Biden administration has a policy that only people with criminal conviction should be placed in removal proceedings. So even those who are already in removal proceedings, who do not have criminal conviction and all of that, many of them are being released. Many of such cases are being administratively closed so as to not remove them from the United States. So that depends on the policy of the current administration. So the fact that Biden administration is doing that right now does not mean that what is going to continue forever, because a new government may come into power and introduce a new policy. So that depends entirely on the policy of the government in power. The next question: national interest waiver National interest waiver petitions are only for PhD holders in science and tech field. No, national interest waiver is for everybody that meets the requirement. It could be in the field of science, it could be art, it could be business, it could be technology, it could be investment, it could be any skill that you have. The only thing is you just have to show how that field will benefit the United States to a greater extent than what an average American citizen will provide to the country, which will warrant the reason of the government waiving labor certification on your behalf. So it is not limited to a PhD holder. Actually, in this office, I have filed national interest waiver for people with a master's degree which were approved. So it doesn't have to be a PhD holder, and it doesn't have to be in science only. It is in every field of life, every field. Whatever job you are doing must be exactly the same job that the employer petitioned for you. So, in other words, if your I-360 was filed on the ground that you will be a pastor, or maybe you will be maybe a youth pastor, you cannot go and start working for a secular company. No, you will not be eligible. But if your adjustment of status application has been pending for more than 180 days and you choose to work for a different employer in a religious capacity as a youth pastor, the same exact position that was petitioned for you, yes, you may not get into any trouble with that. But if you go and work for a different employer in a different capacity, then it may affect your green card. Because at any time before the uh, green card is approved, the 485 is approved, immigration may contact the employer and ask the employer to verify that you are still an employee in that organization. And if they say no, you have left, that may lead to your application being denied. The next question: you have to be in the United States to apply for a green card. No, there are multiple ways to apply for green card. You can apply for green card while you are inside the United States. You can also apply for green card from outside the United States. When you are applying from inside the United States, that is what is called adjustment of status. When you are applying from outside the United States, that is what is called consular processing. But either way, you can apply for green card either in the US or outside the US. The next question: my parents brought me here illegally when I was a child, and I've been living here since then. I just became a US citizen. My parents want me to petition for them, and my friend said it is easy and they should be able to get their green card in a few months. Well, this question is not very detailed enough. It's not detailed enough because you didn't state where your parents are, whether they are in the US or they are outside the US. You didn't state what your parents' status are, whether they entered the United States legally or illegally. You are already a US citizen. So if your parents are here in the United States and they enter the US legally, it doesn't matter how long, if they enter legally with a visa, yes, you may be able to apply for adjustment of status for them. But if they are outside the United States, then you can file I-130 petition for them. Upon approval, you can do consular processing. But if your parents are physically here in the US and they entered illegally, then you cannot fix their problem. You cannot. Even though you are a US citizen, you cannot fix their problem because their problem will require them applying for waiver of unlawful presence. And you, as a child, cannot be a qualifying relative for that waiver. But if depending on whether you are filing for your mother, if your mother is married to a permanent resident or a U.S. citizen, yes, she may be able to apply for that waiver because the spouse can act as a qualifying relative. If it is your father you are petitioning for and she is married to a permanent resident or a U.S. citizen, yes, the spouse can serve as a qualifying relative. But if they are not married or if both of them are not legal, then you are out of luck. You may not be able to petition for them because you will not be able to serve as a qualifying relative for them. If they did not enter the U.S. legally, the process will require them leaving the US to go and apply for green card from outside. And if you are the child, you cannot serve as as a qualifying relative for such a waiver. It will not be approved. So if they step out of the country, they will be stopped. They will get stopped. So it is not advisable. The next question. I have a green card, but I was just arrested for carrying a gun without a permit. My criminal defense lawyer is telling me to plead guilty so I can walk away with probation. He said this will not have any ramification on my legal status. That is not true. I will advise you to tell your criminal defense attorney to consult with an experienced immigration attorney. That is not true. But again, I will tell you, immigration is not a one car fits all. Even if you are convicted of a felony, you may be able to apply for what is called readjustment. You may also not be able to do so because there are specific requirements, and if you don't meet this requirement, you cannot readjust. For example, if you enter the US as an immigrant, let's say you won the visa lottery and you came in as an immigrant, or let's say somebody petitioned for you and you entered the United States as an immigrant, then if you are convicted, even if you are married to a US citizen, you will not be eligible for readjustment because the relief of readjustment is not available for anyone who entered the United States as an immigrant. On the other hand, if you enter the US as a visitor, maybe with a B1, B2, or with a non-immigrant visa, and then you adjust your status in the United States and got your green card, yes, if in such a situation, if you have a US citizen spouse or other qualifying relative who can file a petition on your behalf, you may be eligible for readjustment. So the fact of the question here is not sufficient for me to tell you precisely whether this person is eligible or not. But again, immigration is not a one cap fits all. So it depends on the specific fact of each case. So there may be situations where you may be able to get the relief of readjustment. There may be situations where you may not be able to get that relief. So the best advice I will give you before you plead to anything, get consult with an experienced immigration attorney or ask your criminal defense attorney to consult with an experienced immigration attorney, because once you plead guilty, the immigration consequence is real. 99% of the time you may be in danger if you once you plead guilty. So you need to understand that. So you need to seek counsel from an experienced immigration attorney. Next question. I came to the US by telling the officer that I was a US citizen. They detained me but eventually let me go. I never got anything to appear for immigration court. This means they probably forgot about it and I can have my USC spouse file for me. Well, this is a complicated situation. Excuse me. This is a complicated situation because this is not something that can give you a general advice. My advice to you would be to consult with an experienced immigration attorney, because number one, the one of the few things that makes it impossible for anybody to get green card in the United States is what is called false claim to US citizen. If you falsely claim to be a U.S. citizen, there is no waiver for it. There is no waiver for it. You cannot get green card. However, this is where experience matters. There have been situations, there have been cases that we have handled in our office here where we argued that the respondent, the client, did not necessarily mean that US citizen thing. Because sometimes it depends, the law that made this a ground of inadmissibility, that law stated that you must have claim to be a US citizen for the purpose of obtaining a benefit. So, in this case, if you claim to be a US citizen for the purpose of gaining admission into the US, that is a ground for disqualification. That is a ground for disqualification. But again, we cannot determine what they have in your record. It may be that the officer you had conversation with may not even enter it in your file, may not even enter it in your record that you did that. So it depends. So for a case like that, if you engage our services, we usually start with what is called FOIA. We request copies of document in your file, everything in your file. So once we have that, we review it. That will give us an idea of how to proceed. But generally, false claim to a U.S. citizen is a ground for disqualification. The next question. I have an EAD that is in the renewal process. My employer not letting me work, even though I showed them the receipt notice with the extension. They told me that I need an actual EAD. Well, that is illegal. But then what you need to show them is not only the extension, you have to show them the expired EAD, the receipt notice, and the extension notice from USCIS. If you don't show them these three things and they decline your employment, or they terminated your employment or suspended your employment, that will be a violation of federal law. So if you have a lawyer representing you, tell the lawyer to write a letter to your employer, and I'm sure that they will reinstate your employment, because that will be a violation of federal law. The law says that if you have an EAD that is expired, you have a pending application for renewal, and you have the basis for it, then your EAD, upon the extension letter, the employer is required, mandated by law, to allow you to continue working. So if they disagree, let your lawyer write them, and that will be a violation of federal law. What is this third page? These are not questions. Okay, you just want me to explain this? For example, the first one says case law override federal law for immigrants. Well, that may be true depending on where the case law came from. Case law override federal law, because usually federal laws are made by the Congress. It says case law override federal law for immigrants. Oh, okay. Can state law override federal law for immigrants? Oh, state law. Oh, I thought I saw case law. No. No. Not only for immigrants. In any situation, state law can never override federal law. Federal law have overriding effect. However, you have to be mindful. There are certain things. You see, when we are talking about law, there are three types of laws. There is something called exclusive legislative list. For exclusive legislative list, those are the kind of laws that only federal government can regulate. One of such is immigration. It is only the federal law that can regulate immigration. Any state law that purportedly regulates immigration is illegal. So there's nothing to compare. So it is only federal law that can regulate immigration or anything relating to exclusive list. For example, only the federal government can declare war. No state can do that. Only the federal government can regulate relating to money. Only the federal government can print money. No state can do all those things. Those are examples of laws that are in exclusive legislative list. On the other hand, there are some laws that are in what is called concurrent legislative list, meaning that both federal and state can adjudicate on them. In such situation, state laws will be valid within the state, federal law will be valid within the entire country. So where there is a conflict between the two, federal law will override. Let me give you an example of that. In some states in the United States, cannabis is legal. I believe in Colorado is one of those states where cannabis is legal. But as of today, under federal law, cannabis is still illegal. So if you smoke or buy or possess cannabis in Colorado, the state police may not have anything to do with you, but if you get arrested by federal authorities, you will definitely go to jail because federal law will override the state law. Even though you live in the state and the state makes it legal, because federal law makes it illegal, you will go to jail in such a situation. So federal laws always override a state law. But for immigration, there is no state that has the authority to legislate over immigration. So that is the exclusive jurisdiction of the federal law. The next question. Are there countries where it is easier to obtain visa to enter the US? Well, there may be, but I don't know the answer to that. But I do know that some countries, if you have the passport of certain countries, you do not need visa to come to the US. For example, if you are a Canadian citizen, if you are carrying a Canadian passport, you do not need visa to come to the US. If you are carrying a British passport, I don't believe you need visa to come to the US. Many European countries, you do not need visa to come to the US if you have their passport. 3 months, and the husband's application was not processed in 2 years. Even though the husband was the principal when they applied for green card and the wife was only a derivative. But when we apply for citizenship, the wife's application was approved within months, whereas the husband's application was still pending even after 2 years. So nothing is certain because, number one, once the application get to the filing center, they are separated. Number two, each person is going to provide fingerprinting, biometrics for immigration to use. And the FBI report may not come back at the same time. And number three, it depends on where each person's life, how complicated each person's life is. Because when it comes to background check, some people, their background will clear right away. For some people, it will be a complicated process. So there are lots and lots of factors that affect it. And secondly, cases may be assigned to different officers. There have been situations where we file application for citizenship for husband and wife, and both of them were scheduled for interview the same day, only to get to the interview and to the officer, and then the officer will conduct the first interview and then tell us, oh, I don't have the file for the other one. And we realize that that file is assigned to a different officer. So a lot of things can happen. It is not likely that because you filed at the same time, it will be processed at the same time. No, that is not true. The next question, excuse me. Is it true that USCIS has a backlog in cases filing? Yes, that is extremely true. That is very, very true. There's been lot and lot of backlog, and a lot of factors contributed to this. Every single case is backlog right now. Number one, when President Trump became president in 2016, they increased the enforcement, they increased immigration enforcement. And because of the increase in enforcement, many people started submitting all kinds of applications, even application that does not have merit. They just want to show that they have something pending so that they can avoid being placed in removal proceedings or avoid being removed from the United States or being deported, as the case may be. So that increased the volume. So as the volume was increasing, then came COVID. So when COVID struck, sometimes the government was shut down, and a lot of things happened. A lot of immigration offices were shut down. Then people continued to file, but there was nobody to process it because many of the immigration officers themselves, they were facing COVID, they were facing a lot of challenges. A lot of immigration offices were closed, and because of the CDC, because of the CDC position at the time or policy at the time, sometimes when someone tested positive at an immigration office, the entire immigration office will be shut down for days or weeks because they want to clean the office, they want to disinfect the office. So lot and lot of things continue to created a backlog. Then, because of COVID again, another effect of COVID, immigration, USCIS, is the only federal agency that is self-funded. The Congress does not fund them. It is only the payment from the filing fees that they use to sustain themselves. So when the government shut down and people were not able to file, immigration lost a lot of money because when there were no new applications, there could not be new fees. So they lost about 45% of their income. So that again also affected their performance because many things they needed to do, they didn't have the funds to do it. And of course, the Congress did not come to their rescue. In fact, immigration had to increase some of the filing fees in order to cope with the level of backlog. But since the new administration, they are trying their best to kind of clear up this backlog, but it is all over. It is this same problem that affected the Department of State. So if you have a case that is pending at the embassy, it is the same problem that is affecting them. So there are lots and lots of backlog everywhere. But right now, the government is trying everything possible to reduce the backlog. And as far as citizenship is concerned, I believe they have succeeded in bringing that back to the pre-COVID era. Right now, citizenship are being processed within 6 months. So we believe that other applications will be affected as well. But lots and lots and lots of backlog right now. That is very true. The next question. What causes processing time to fluctuate? Well, again, I just explained the backlog problem. So once there is a backlog, there will be a lot of processing time delay. But I'm suspecting that this question was probably going to ask about visa bulletin, because as for processing time, because of all the problem that I explained which created backlog, everybody whose case is delayed is calling immigration, doing service requests, asking questions. Oh, what is the status of my case? When are you going to get to my case? Everybody is concerned and everybody wants attention. So these sometimes create overwhelming situation for immigration. So in order to avoid people calling them every time, so they always increase the processing time. So ordinarily, an application that will be processed within 12 months, they can put the processing time at 24 months so as to give themselves enough time so that when you call, they will tell you, oh, we are still within the processing time. Or when you try to do a service request, the system will not allow you. It will tell you you are still within processing time. This is just to give themselves enough time and to relieve themselves of pressure. So the fact that they posted 24 months for a 12-month process does not necessarily mean that the case will be delayed for 24 months. But they are saying that don't call us, don't contact us within the next 24 months. So those are some of the reasons why processing times keep getting increased. The next question: is it true that some USCIS officers purposefully create delay for people of a certain race, ethnicity? No, I don't have any evidence of that. I don't believe that is true. The next question: does USCIS transfer my case to other offices because there is a problem with my case? No. Sometimes for applications that are processed in multiple locations, it is not every type of application that are processed in multiple locations. There are some applications that are processed in specific locations, and those kind of applications, you are stopped. If that application is processed in that place, no other office can handle it. For example, if you apply for a religious-based petition, it is only processed at the California Service Center. So if your case is in California Service Center, it can only be handled by California Service Center, because those are specialized offices. Those are offices that are trained specifically to process this type of application. So it is only those applications. But for applications that can be processed in multiple locations, multiple states, multiple jurisdictions, those type of applications, sometimes some offices, their processing time is extremely low, whereas some other offices, their processing time is extremely high. I think it was yesterday I was checking processing time for someone, and the person does not have the receipt notice, so I wasn't sure exactly which office the case was pending. So I decided to check all service centers. For that particular application, there was a service center that processed that application within 4 months, whereas another service center for that same application, it was taking 25 months. So you can imagine. So sometimes USCIS can transfer some of the application currently pending in the office where there's a lot of backlog. They can transfer it to other offices so that at least there can be some kind of balance between them. So they do that from time to time. So it doesn't necessarily mean that there's a problem with your case. The next question: if I file different types of forms for myself at the same time, will they all be processed together and at the same time? Well, it depends on the type of forms that you are talking about. But usually, forms are, that is why sometimes you may see I-485 that has been denied or even approved. You will still see the employment authorization being processed after a final decision has been taken on the I-485. This happens because they are processed in different offices by different officers. The next question: my friend has an online account where he receives updates on his case. Can I also sign up for an online account? Well, number one, if your case is eligible for online account, yes, you can do that. But usually, online accounts are set up at the time you file, because they are going to give you certain numbers that you are going to use to create the online account. So if you allow this number to expire, if you attempt to register subsequently, you may not be able to do so. But yes, if you have an online, if your case is eligible for online account, yes, you can follow it online. But it is not every case that is eligible for online account. Next question: I feel like USCIS is discriminating against me and my case. What can I do? Well, to be honest with you, I don't have any evidence of discrimination. I mean, we have been doing this case for some time now. We have been practicing immigration law for some time. I don't have any evidence of discrimination. It is the same thing that applies to everybody: brown, blue, white, black, African, Asian, American. Is the same law that applies to everybody. What matters is your application. Is your application complete? So what matters is your application. Is your application complete? So I don't know what usually the law state that if immigration becomes aware, or if they come to the information that may make a case, never call you and start asking you for your bank details. USCIS will never call you to start asking you about your social security. USCIS will not call you to ask for those things. Those are fraud. If you not call you to ask for those things, those are fraud. If you receive such a call, check information. Okay, I see information. Okay, I see that we have a lot of questions here. I have office. So if you are in this situation, you don't have tax ID, you are working and you want to file your taxes, contact us and we will issue you a tax ID number. But of course, with interviews for all adjustment of status applications, that is not true. Then an interview will be scheduled. Sometimes the system miss it. I've seen a situation, a case that I believe that is very straight, joint sponsor, to show that they will support you and you will not be a liability to the government. That is a requirement that has. If FBI background check comes back to show that